Article 251 of the Revised Penal Code is your death caused in a tumultuous affray. Let's go to the elements. Number one, there must be several persons, and these several persons do not compose groups organized for the common purpose of assaulting and attacking each other reciprocally. And these several persons quarreled and assaulted one another in a confused and tumultuous manner, but someone was killed in the course of the affray, but it cannot be ascertained who actually killed the deceased. But the person or persons who inflicted the serious physical injuries or the person or persons who used violence can be identified. Let's go to element number one. There must be several persons. Question: how many is that several persons? Answer is at least four. At least four individuals or at least four persons. Where did we get the number 4? That is very clear according to your Article 153, third paragraph. If caused by more than 3 persons who are armed or provided with means of violence, then that is considered or that shall be deemed tumultuous. So take note ha, at least 4 individuals or at least 4 persons. Please take note of element number 2 kasi marami ang nakukonfuse dyan. That several persons must not compose groups organized for the common purpose of assaulting and attacking each other reciprocally. That is the reason why if there are 2 identified groups of men who are assaulting each other, then there is no tumultuous affray. There is no crime of death in tumultuous affray if the quarrel is between 2 well-known groups. To better understand element number 2, let's read this 2020 case decided by the Supreme Court. So on May 5, 2011 at around 9 o'clock in the evening, itong si Gary, Arnold, Eliza, and Joyce Ann arrived in their house in Pampanga. The group told Romeo, Rommel, Richard, and Albert, you take note ha, ang apelido nilang lahat is Santos, that they were being chased and stoned by the Lacsons. Arnold then left, but while he was running toward the house of the Lacson, the group followed and tried to pacify Arnold, but they failed. Upon reaching the house of the Lacson, Arnold had a heated discussion with Hernani and Eliezer. Moments later, Rudy Santos, who resides at the back of the Lacson's house, also arrived. But here comes Deborah. Sino si Deborah? She is the wife of Hernani. Deborah brought out a steel pipe out of their house and told her husband, here is a steel pipe, you hit them. Eduardo Lacson responded by hitting the head of Arnold Santos with a steel pipe. The Santoses wanted to help Arnold, who fell on the ground, but the Lacsons likewise attacked them using steel pipes. As a result, Rommel Santos, Gary Santos, Richard Santos, and Romeo Santos sustained injuries on their heads and different parts of their bodies. So ito yung facts ha, magulo. Kung kayo ay magiging fiscal at sa inyo to nakasalang, for sure sasakit ang ulo ninyo. But what was the issue raised here? One of the issues raised by the accused is it should be considered as a tumultuous affray. Did the Supreme Court agree? Answer is no. Ano ang sabi ng Supreme Court? In the present case, the dispute was between 2 distinct groups of individuals, the Santoses and the Lacsons. Clearly, this was a definite attack on the Santoses by the Lacsons, an identified group. Again, what did we say? If there are 2 identified groups of men who assaulted each other, then there is no tumultuous affray. Element number 3. These several persons quarreled and assaulted one another in a confused and tumultuous manner. Dapat the assault must be in a confused and this organized manner resulting either in the death or injuries of the ones involved, and the person responsible could not be determined. That is the meaning of your tumultuous affray according to the Supreme Court. Take note, however, that if there is conspiracy, then Article 251 is not committed. In that case, the crime would be either murder or homicide. Let's go to element number 4. Someone was killed in the course of the affray. But who is that someone? Who is your victim in tumultuous affray? If you read closely Article 251, mababasa mo that the person killed in the course of the affray need not be one of the participants in the fight. The article speaks only of someone killed. Therefore, that someone could either be a participant in the fight or a mere passerby. Let's discuss now elements number 5 and 6. It cannot be ascertained who actually killed the deceased, but the person or persons who inflicted serious physical injuries or the person or persons who used violence can be identified. So who is liable under Article 251? Answer is, if you know the person who inflicted the mortal wound or that fatal wound, then that person alone shall be liable for homicide. Take note ha, homicide muna. But if he is not known, then the person or persons who inflicted the serious physical injuries are liable under Article 251, death caused in a tumultuous affray. Number 3, if it is not known who inflicted the serious physical injuries on the deceased, but all the persons who used violence upon the person of the victim are liable under Article 251. But take note that the liability is lesser. Let's go now to bar exam question. Itong si Celia is nagpa-birthday party. Nagpa-birthday si Madam. But what happened? A turbulent commotion took place involving no less than 40 na guests, during which occasion Tito was killed by shots fired from a .45 caliber pistol. The fiscal filed the case of death in tumultuous affray against all the participants in the melee. Question, do you agree? Answer is no. That charge of Article 251 against all the participants in the melee is not proper. Bakit? What did we say? For Article 251 to apply, the killer of the person killed in the course of the affray cannot be ascertained. He must not be known. Ang sabi nga natin, if the person who inflicted the fatal wound or the mortal wound is known, then that person will be liable for homicide. In our problem, since it is very clear that Tito was killed by shots coming from a .45 caliber pistol, then that person is the one responsible for his death. Another bar exam question. During a town fiesta, there was a free-for-all fight that erupted in the public plaza. As a result of that tumultuous affray, A died. B, C, D, and E were proven to be participants in the rumble, each using a knife against A. But it could not be ascertained who among B, C, D, and E inflicted the mortal injury. Question, who shall be held criminally liable for the death of A and for what? Answer is B, C, D, and E are all liable for death caused in a tumultuous affray. Ano ulit ang sinabi natin? If it cannot be ascertained who among B, C, D, and E inflicted the mortal injury on A, then you go to number 2. What is rule number 2? The person or persons who inflicted the serious physical injuries is liable under Article 251. Let's go to another bar exam question. A, B, and C are members of SFC Fraternity. While they were eating in a seaside restaurant, they were attacked by X, Y, and Z. Sino si X, Y, and Z? They are members of a rival fraternity. A rumble ensued, and members of the two fraternities assaulted each other in a confused and tumultuous manner, resulting in the death of A. Since it cannot be ascertained who actually killed A, the members of the two fraternities who took part in the rumble were charged for death caused in a tumultuous affray. Question: will that charge prosper? Answer is no. The charge will not prosper. Bakit? What did we say again? Go to element number 2. If there are two identified groups of men who assaulted each other, then there is no tumultuous affray. There is no crime of death in tumultuous affray if the quarrel is between two well-known groups. Going back to our problem, there is no tumultuous affray since the participants in that rumble belong to organized fraternities. Therefore, the killer of A is definitely a member of the rival fraternity. He could not be a member of the SFC fraternity where A belongs. Let's go now to Article 252 of the Revised Penal Code, Physical Injuries Inflicted in a Tumultuous Affray. Elements: number 1, there is a tumultuous affray as referred to in Article 251. Number 2, a participant or some participants suffer serious physical injuries or physical injuries of a less serious nature only. But the person responsible cannot be identified, but all those who appear to have used violence upon the person of the offended party are known. Take note that the victim or the injured party in the crime of physical injuries inflicted in a tumultuous affray must be one of the participants or some of the participants. That is very clear according to your Article 252. Ang nakasulat talaga dyan is upon the participants. So very clear. This is very different when you go to your Article 251. Ano ang ulit ang sinabi natin? Sa Article 251, ang nakasulat lang dyan is someone is killed. And that someone or the person killed need not be one of the participants in the affray. Therefore, your victim in Article 251 may be a participant or a non-participant. Take note that in physical injuries inflicted in a tumultuous affray, only those who used violence are punished. Because if the one who caused the physical injuries is known, then that person is liable for the physical injuries actually committed and not under Article 252. And if nobody could still be traced to have employed violence upon the victim, then nobody will answer. Nobody is liable. But in that case, ano ang pwede mo pang ma-file? Maybe you can file disturbance of public order, or if there are participants who are armed, then you can file tumultuous disturbance, or if property was destroyed, then you could file malicious mischief. You take note of the interplay ng mga crimes na ito.